mind, I'm going to switch my camera off so that you're not distracted by me and I can focus on the substance. Today, I'm going to assume that people are familiar with climate change and competition law, although I will mention key provisions as they are relevant. What I want to look at is the relationship between those two concepts in the context of agreements, abuse of monopoly power, and mergers. In one sense, I apologize that this is focused almost exclusively on European law, but many regimes, competition antitrust regimes around the world have been modeled on EU law, so I think people will see the relevance there. But equally importantly, I think many of the principles about which I'm talking can be applied in other countries or adapted to apply in other countries. You might well ask, what has competition law got to do with climate change? In one sense, it has a lot to do with it, because competition law, competition is part of a capitalist system which encourages us all to produce and consume more and more goods, using up more and more of the world's resources. Now, I'm not here to challenge the capitalist system. Indeed, I'm a member of the establishment. What I'm trying to show is what we can do within the system, within the laws that we have. And I accept that in some ways competition law, you could say, has got a little to do with it. But if I decide personally to stop eating beef, to cycle to work, to take the train and not a plane, I can only make a little difference on a personal basis. But everyone is called upon to make our contribution to the necessary change, as the European Commissioner Vestager said at a recent conference on sustainability and competition law. And I've been thinking about this for the last 6 months or so, and I've decided we must do something within our own area of expertise, and I believe we have the legal tools to do that. For me, the most important issue is that competition law should not stand in the way of necessary cooperation between companies. As again, as Commissioner Vestager said, that is often the most efficient way for changes to be made to fight climate change. But if companies act individually, they will often increase their costs and suffer what we call a first mover disadvantage. If you raise your standards for car emissions, that comes at a price. And we have seen that car manufacturers have, in my view, legitimately cooperated to raise car emission standards. In my own experience as a private practice lawyer for 35 years, I've worked on projects to increase recycling rates, to reduce packaging where companies have cooperated perfectly legally. An example the UK Competition Authority gave was efforts to phase out inefficient light bulbs that didn't last as long as they should do, or a scheme approved by the European Commission to phase out inefficient washing machines. I'd emphasize at the beginning, we're not talking about what some people call greenwashing. If companies cheat on the car emission system, the full force of the law should be applied to them. If, as in the 1920s, there were a scheme to reduce the life of a light bulb, that again would be highly anti-competitive, and should, again, competition law should apply. The problem is, in my view, that advisors and the authorities are too risk averse. Commissioner Vestager herself recognized that. In my own experience, this is having a bad effect. For example, recently I was asked to advise in relation to an initiative to encourage sustainable fishing. Suppliers, retailers would not buy from unsustainable sources of fish. One retailer, one of the biggest in Europe, said, we cannot sign this because we are afraid this is a collective boycott. They weren't going to do anything unsustainable, but they were afraid to sign it. It could have upset the whole system. The European Parliament has also recognized that competition law is a barrier to vital action. So I'm just going to try. Apologies, I should have changed my slide earlier. Moving on. We have the legal tools, as I said earlier, and in Europe we have both the constitutional provisions and the competition provisions, which I think are very helpful here. And I'm going to focus on what the law actually says, and I'm not going to focus on what I've called imported and often unhelpful or abstract concepts such as consumer welfare, public interest, non-economic factors, non-competition factors. Let's get back to what the law actually says and lets us do. The constitutional provisions of the treaty, I'm not going to take you through all these. Hopefully you can see some of the key ones on the screen. And I fully accept that what some of the terms here mean, sustainable, fair trade, these are difficult concepts. But what I'm saying is that nobody can say that these are not relevant to the treaties or to the application of competition law. Where there is a conflict between different concepts, then we exercise judgment and apply the well-established proportionality principles. The one provision I will mention is Article 11 of the Treaty on the Functioning of the European Union. You can see that here, but it's worth reading in full. Environmental protection requirements must be integrated into the definition and interpretation of the Union's policies and activities, in particular with a view to promoting sustainable development. Now, can anybody tell me where it says except when applying competition law? Of course it doesn't. We must use these concepts when applying competition law. In my paper, which is about to be published in the Journal of Antitrust Enforcement by Oxford, I set this out in a lot of detail as to how I think these provisions can apply in particular contexts. What I want to do today is to give you an idea of the key relevance of these concepts in different areas of competition law. Before I do that, I feel obliged, against my better judgment, to say just a word about consumer welfare, because people talk about it so much in academic circles. In my view, this is an unnecessary detour. Where does it talk about consumer welfare anywhere in the treaties, or indeed in the antitrust laws of other systems? Nowhere. It's an unnecessary import invented by the likes of the Chicago School and neoliberal movement and so forth. And before people think I'm attacking the US system, I'm not. Many in the US are also criticizing a narrow use of the term consumer welfare. But actually, if it were in our treaties, if it were in our laws, it could be quite a good test. If you look up what consumer welfare means, it refers to the health, happiness, and the future of a person or group. It refers to well-being and good health. This concept is perfectly capable of encompassing having clean air to breathe, producing goods using fewer resources, or having enough food to eat. It's at least as relevant to those as concepts such as lower price. Not that lower prices are not important. In my view, we focus too much on highly theoretical discussions about issues such as consumer welfare. And when I've been struggling with this, a picture came to my mind of the story of the Roman Emperor Nero playing the violin whilst Rome was burning in front of him. And my picture here illustrates everybody talking about all these strange abstract concepts rather than doing something whilst climate change carries on at a frightening pace. So let's get back and talk about what the treaties actually say, what our laws say, rather than what they don't say. The most important of these, to my mind, in an EU context is Article 101. Article 101 of our treaty is the one that prohibits anti-competitive agreements, but provides for an exemption if certain conditions are met. In my paper, I set out 5 ways in which an agreement to promote sustainability, to fight climate change, might escape that prohibition. Exactly how they escape them doesn't really matter. Again, academics can write a lot about which one applies. I don't really care, so long as one of them, where appropriate, provides a way of getting on with vital work. I'll mention them only briefly today. Again, there is more detail in my paper. Of course, many agreements, in fact, most agreements, don't restrict competition at all. We should never lose sight of that. The European Commission's 2001 horizontal guidelines set out some helpful guidance as to when agreements might not, sustainability agreements might not be caught by competition law. Unfortunately, they're not in the current guidelines, but I'm hopeful, indeed increasingly confident, that in the revised guidelines from the European Commission, sustainability will once again find its place. We have many examples in the cases where agreements have been found not to be caught, agreements to reduce emissions, for example. And one I'll mention here, the Fair Wear Foundation living wage. This was an agreement by people buying textiles from suppliers in all parts of the world, largely poor parts of the world, an agreement to pay them a living wage, a fair wage. And an opinion was obtained from one of the leading law firms saying that in the real world, this was not caught by competition law, and the risk of enforcement action being taken was low. And an interesting point, the European Commission, I know personally, was involved behind the scenes and said that would not take action. But frustratingly, they would not say anything publicly. And that's part of the problem. Often when I talk to officials, they say, well, Simon, that's not a problem at all. But they're not sending that message out in what they're saying publicly. What they say to me over a nice dinner or over a couple of beers is quite different to what you tend to hear in conferences. I won't go into the next one. That's an idea I have based upon a leading judgment of the European Court. I'm happy to talk about that if people are interested. I won't say much about the next one either. That some of you may be familiar with the so-called ancillary restraints or objective necessity doctrine. But basically, this provides the possibility that sustainability agreements which contain proportionate restrictions, without which the agreement would not be concluded, or which are necessary to carry out an environmental regulatory task, may be held not to fall within Article 101 at all. Cases like Albany and Wouters provide the legal basis for that. It's been objected that, oh, this hasn't been tested. Well, if it hasn't been tested in a sustainability context, that, to my mind, is an opportunity, not a problem. The one I do want to say a few words about is Article 101.3. Article 101.3 enables agreements which meet each of 4 conditions to be exempted. There has been masses of academic literature written about this, discussing things like, again, consumer welfare, non-economic factors. What's curious is that so often this discussion doesn't mention the law. I was at a high-level conference in London a few weeks ago, pre-COVID-19, unfortunately, I would add, and a number of leading economists and lawyers, all experts in their field, discussed this. Not one of them actually mentioned what the law says. And that's what I'm going to do. I'm going to look at what the law actually says. And remember, we should be interpreting this in the light of the constitutional provisions to which I referred a moment ago. The first condition for an exemption is that an agreement must contribute to improving the production or distribution of goods or to promoting economic progress. Now, I could talk a lot about this, but I think people tend to make 2 mistakes, and I would say I have made both mistakes myself in the past. One is the economic element here is only one of 4 ways in which something can be exempted. An agreement could be looking to improve production. It could be looking to improve distribution. It could be looking to promote technical progress. It's not just about economic progress. And you can see how many sustainability initiatives will fall into one of those 4 categories, including, of course, the economic progress. So let's hear people talking about, can we get non-economic factors into competition law? Economic factors, economic progress is one of 4 ways in which something can be approved. And the second mistake is people often say, Article 101 prohibits anti-competitive agreements. Article 101.3 allows them to be exempt if the pro-competitive effects outweigh those. No, it doesn't say that. It doesn't say that at all. It says what is written on this slide. Saying that you look at the pro-competitive effects is a convenient shorthand with non-technical clients sometimes, and I've done that many times myself, but it is lazy and will often lead us to the wrong answer. We should look at what Article 101.3 actually says. The second condition is that the agreement must allow consumers to have a fair share of the resulting benefit. There's a lot of debate over which consumers can benefit, and again, I can happy to take questions on that. But the constitutional provisions and the fact that environmental benefits are clearly recognised as consumer benefits suggests that you cannot take a narrow view of this. And leading cases such as the CSED case, the Commission said the environmental results for society would adequately allow consumers a fair share of the resulting benefit, even if no benefits accrued to individual producers. The point I'd like to emphasise here is that we must, making this judgment about a fair share, we must give proper weight to what really matters. What weight do we give to something being 1 cent, £1, $1 less, cheaper? And what weight do we give to things that really matter? Climate change, the health, the air our children will breathe. Now, there is a need for constructive dialogue between those of us who are looking for competition or not to get in the way of vital initiatives, and to work with the enforcers here. Because I think from talking to senior officials, this is one of the ways, one of the biggest obstacles to competition enforcers getting comfortable with this. And again, I've made some suggestions in my paper, and I rewrote this section after discussions with the people at the European Commission. The third condition is that the agreements must be no more restrictive than necessary, and I fully accept that some desirable sustainability agreements will fail because of this. That's fair enough. An agreement, for example, an agreement to pass on costs to consumers, however beneficial, may not be no more restrictive than necessary. You collaborate to achieve some sustainability objective, but then you compete when you're selling your products to the customers. An agreement to pay better prices to farmers may be okay in some instances, but there are maybe less restrictive ways of achieving that similar level of support. You have to look at those case by case. And finally, there must be no elimination of competition. That's rarely going to be relevant here, and I won't say anything more about it. The other way, final way in which I mention is you might escape the prohibition of Article 101 is to have a standardization agreement. The Commission gave guidance on that in the 2010 horizontal guidelines, and many commentators have said that that may be a way to get sustainability agreements falling outside 101. Again, I won't say more about that. I wanted to leave some time to say a bit about dominance, or abuse of dominance and mergers. First of all, abuse of dominance. Article 102 of the treaty prohibits any abuse of a dominant position. And I think that exceptionally, we could use Article 102 as what I call a sword to attack unsustainable practices by dominant companies. If we can attack unfairly low prices, think of predatory pricing or exclusionary rebates, or excessive selling prices, think of cases like Pfizer recently, why not unfairly low purchase prices? And that's in our treaty. Article 102A refers specifically to unfair purchase or selling prices or other unfair trading conditions. Of course, it's difficult, but we do have the tools. If we can devise methodologies for predatory pricing or excessive pricing, we can do so for unfair purchase pricing. I'd emphasize that I think this is only going to be exceptional. In many cases, there won't be a dominance, you won't find dominance anyway. And regulation is usually the best option or first choice. But we should not forget Article 102 if there is a regulatory gap and the regulations are not taking care of things. And again, the European Parliament has called upon the Commission to do something about this. The other comment here is that some national laws specifically make provision for this. Italy being an example. And then my second point on dominance is that I think it's quite possible that proportionate behaviour to tackle environmental or climate change issues, which might otherwise have been considered to be abusive, maybe not amount to an abuse, as long as there is no less restrictive way of doing it. In other words, there's an objective justification. Again, I give some examples in my paper, but I'll mention perhaps just one of them. Supposing I refuse to supply somebody by denying them access to my facility. For example, I deny access to my petrol station or my refueling center to diesel vehicles, and I don't discriminate. I think that could be a defense to a refusal to supply. But my big message here is I think we should help big companies to do the right thing. Many big companies are those with the economic weight to actually make a difference. And many companies are trying to do the right thing. I'm not trying to in any way excuse greenwashing, but we should not let competition law be any more of a hindrance to these companies and the many people within them trying to do the right thing. So finally, before the third area is mergers. Now, some of this is more EU specific. My paper looks at 5 aspects and 5 ways in which sustainability may be relevant in a merger context. But perhaps here I'll just make 3 points. First of all, for those familiar with the EU merger regulation, the assessment criteria include development of technical and economic progress. And the wording is similar to that to which I referred a moment ago in talking about the exemption provisions in Article 101. The second point I would perhaps prefer to mention today is remedies. Mergers can be cleared unconditionally or subject to remedies or commitments, as we sometimes call them. And I think we could potentially make greater use of remedies as I might even call it a compromise. I'll give you an example. Supposing a German company and a French company merge, they each have one factory, and the rationale of the merger is to close the factory in France and to expand the one in Germany to achieve economies of scale and scope. Now, there is an economic efficiency. Now, I'm not standing here as an environmentalist saying this merger shouldn't be allowed. What I'm suggesting, although that's not completely excluded, but what I'm suggesting is that why not allow the merger to get the economic efficiencies, but let's have some remedies that deal with the harms, the real harms that it's causing. For example, people in France will be made unemployed. Why not make it conditional upon retraining those workers for other work? And in Germany, the expansion of the factory could lead to environmental damage, more pollution, more noise, more trucks going in and out. You could have environmental abatement conditions attached to the merger. And the third comment that I would just like to illustrate is, don't forget, many cases fall to national rules, and many countries, such as Germany, have the potential for the state to approve or block a merger where the competition authority has taken a different decision. And just as I was writing my paper, the Germans gave me a present in the Miebe-Zollern case. The German government cleared a deal that had been blocked by the German Bundeskartellamt, their competition authority. It said that the positive effects of the deal for the environment and climate change outweighed the competitive disadvantages. And they cited noise reduction, reduced fuel consumption, and more generally, climate protection and sustainable development policy. But is all this too difficult? I'm getting quite frustrated at conferences where some officials or some lawyers, some economists seem very sympathetic to the idea of fighting climate change, but then say, oh, but it's all too difficult. Oh, but it's tricky. But I think what I'm trying to show is that within our system, both the legal tools and policy considerations all point towards taking climate change and sustainability considerations into account in a modern competition policy. And we shouldn't just be looking for ways to not to achieve that. We should be looking for ways to use competition tools constructively. I've set out a whole chapter now in my paper dealing with these objections that people keep coming up with. I sometimes think people are working very hard trying to find a reason not to use competition law constructively, or put another way, to use competition law in a destructive way. First point I'd make is that we must apply the law anyway, and I've referred to what the law actually says, particularly the constitutional provisions. And if we don't focus on what is important, we risk competition law, antitrust law being seen as irrelevant. Indeed, there's quite a widespread view that antitrust law has been seen as pretty irrelevant in the United States for some while. Sometimes it's suggested that, oh, this is too difficult. That sort of implies that taking a narrow, price-centric, short-term view is easy. It is not. I can tell you, if I'm sitting in the Competition Appeal Tribunal as a judge, and one side gives me 200 pages of economics that says, for example, that there has been no pass-on in a cartel case, and the other side gives me 200 pages of econometrics saying it's all been passed on to customers, that is not easy. Anybody who thinks that is easy has either never come across this situation or is deluding themselves. And just to comment on one other point, maybe two. This is an economic approach. It is not a non-economic approach. We can use all the tools available to modern economics, environmental economics. We can use quantitative techniques, indeed taking into account externalities or true price, or true costs or true price. It's very much an economic exercise. There's a lot of work for economists to do to help us with this. The final comment, some people say when I talk about climate change, yes, but where do we stop? There are so many considerations in the Constitution, in the constitutional provisions. And what about welfare? What about employment? What about this? What about that? Well, I'd make 2 points. One, we face an existential threat and a climate emergency. If we're ever going to single out one thing to really focus on in applying, in tempering competition law, it is the climate emergency. Other issues should be considered on their merit, but if other issues do not pass the test, that should not be a reason for not taking into account climate change in an appropriate manner. And the final comment is, yes, we still need regulation. People sometimes say, isn't regulation better? Yes, regulation is probably better in most circumstances, but where regulation is too inadequate, it is too national, it's too slow coming, then companies we should not stand in the way of companies taking the vital action that is needed. My heading here is it all too difficult? Having listened to so many people in the conference, I'm tempted to change that and to borrow some words from President Obama. Yes, we can, is perhaps going to be the title on the next edition of my article. So in conclusion, a narrow approach is not necessary. A narrow approach to competition law. By that I mean focusing just on short-term price effects and other more restrictive approaches. This is an obstacle to vital steps to combat climate change. And we can do a lot without changing the law. We need to revisit the law and economics. Many people here, in fact, probably most people here, have been involved with competition law, antitrust law in many ways. Are we really happy, personally, individually, that it's doing its job? Yes, it's prohibiting some bad cartels. Yes, it is allowing some helpful mergers, blocking some anti-competitive ones. But if it is really standing in the way of vital action by companies, and I'm sure it is, then I'm not comfortable being part of the competition establishment. What we need to do is to give more robust and realistic advice. But changes, I recognize, may still be necessary. The establishment, we live in a conservative world, and the establishment is pretty conservative. It may need help to give that robust advice. Now, in my paper, I conclude with 10 concrete steps that I would like to see being taken. I'll mention just 2 of them. I think top of my list is more positive statements from the competition authorities. Industry quite rightly hears from competition authorities about what they can't do. You mustn't collude with your competitors, you must not fix prices, etc. Quite right. But they don't hear the positive side. The European Commission, since 2003, has had the power to issue positive decisions. It has not once done so, not once in the last, whatever that is, 15, 16, 17 years, issued a positive decision. And the second thing I'd like to see is an updating of the Commission's guidelines and notices and prioritization principles from the authorities. The Dutch have done that well. I'm delighted to see that the UK, for the first time ever in its annual plan, published last week, week before, has included climate change in it. Great, we are making progress in this. And finally, COVID-19 is a crisis, but around the world, competition authorities have been relaxing competition laws to deal with the consequences, recognizing that there is vital action, vital collaboration is needed to keep food supply chains working, to keep food on our table. Climate change is also an emergency. In the longer term, it's a bigger issue than COVID-19. And I'm not even asking for competition law to be relaxed. I'm just asking for it to be applied in accordance with the law. So let's not, as we say, let's not fiddle while Rome is burning. And if we take just some of the actions which, if we take just some of the actions that I'm proposing, then I would suggest that competition law can cease to be part of the problem, part of the solution. And if a final comment, if I may, Pablo, if people are interested in this area, we have set up a forum for an inclusive competition forum. If anybody is interested in joining that, very much welcome you on board. And you can, if you Google that, you will find inclusive competition forum with details and details of how to join. So with that, I will pass back to Pablo.
Thank you, Simon. We have received a couple of
any questions.
Yes, we did receive a couple of questions. I will try to give the microphone to some of the participants. Before I go with that, we have a question on, you mentioned at the beginning, you mentioned ancillaries, ancillaries restraints and and you said you would not go further. Could you please comment a little bit further on that and how that's anything to do with sustainability, competition law, and how would you use that on merger control mainly?
Well, no, this is in the context of Article 101, anti-competitive agreements.
Yeah, sorry.
A doctrine was developed over the years where to find that certain agreements did not restrict competition law at all. Some of these it's fairly obvious, and it was a way that which the court found to find that agreements weren't caught at all. And to be honest, one of the reasons why they did this, and I'll give you an example in a moment, was that because there was the national authorities and the individuals did not have a power to grant an exemption. My own personal view, and not many academics would not agree with me, is that we wouldn't have needed this doctrine if we'd had self-assessment and you would have said, look, this agreement is caught, but it meets the criteria for an exemption. But that wasn't a legal possibility in those days. So the courts found ways of saying, well, this agreement, which hasn't been notified to the European Commission, hasn't been approved, actually isn't caught at all. As a matter of, you might almost say common sense, but it would put on much more legalistic terms than that. A good example of that is, for example, if you have agreements relating to doping amongst athletes. Now, that is actually reducing their ability to compete. If I take a drug, we can compete with each other to take more and more drugs, but that is banned by the World Anti-Doping, by the Olympic Committee and all sorts of people. That has been held not to be anti-competitive because there are proportionate restrictions which are necessary to carry out the necessary task, organising international sporting arrangements. Now, I said I don't really care how things are. This is a doctrine there, so why not use it? And to be fair, there are some agreements which, if they were caught, might not meet the criteria for an exemption, but you could say common sense tells you that they're not really anti-competitive in the first place. And my theory is that the more climate change goes up the political agenda, the more likely this could be relevant. For example, if I say, most people, if I refer to the doping example, will say, of course, that's not anti-competitive. But a formal analysis could easily find that to be anti-competitive, but common sense tells you that it is not. Whereas you have an agreement, for example, to minimize, to try and reduce the overcapacity in beef production in Ireland, where they tried that argument, and the court said, no, that is caught, but it merits an exemption. And I think that, but it has to be considered to see whether it merits an exemption. And I think that analysis is correct. But the more we realize that climate change is, fighting climate change is absolutely fundamental, the more society will come to see fighting climate change as more like having anti-doping rules and less like an agreement to curtail capacity in beef production.
Thank you. We have a question from Ignacio Nicholson. I don't know if you see Ignacio right now.
Yeah, I don't. Antonella? Ah.
I'm here?
Yeah, we can listen to you.
Good, good. Thank you, Simon. Thanks for your presentation. My question is whether you believe that competition authorities are prepared to assess the environmental impacts of a merger, or otherwise, if those environmental impacts you believe should be assessed by a different regulatory authority. Thank you.
Yes, well, the approach I'm sure will vary a bit from one authority to another, and then it's perfectly legitimate to make a policy decision either that this is a matter that should be considered by the competition authority, and I think there is scope, limited scope I would add. I'm not suggesting, I'm not somebody who says, so it's been suggested that if you have two mergers coming together, if you have a merger of two companies which reduces price, that will increase the total production, and that is bad for the environment. I'm not in that school of thought at all. I think it's at the margins that environmental considerations come in, but I do think they're relevant. But it is equally possible to have a system where you say, well, we're going to make limited or no use of environmental considerations in the merger control considerations by the competition authorities, but we're going to have a separate regime which considers that. And the approach in Germany, I think, illustrates that very well. That the case I gave you where the Bundeskartellamt was overruled by the economics ministry in Germany illustrates that very well.
Mm-hmm. Thank you.
Thank you. We have another question from Victor Castillejo. Victor?
Hola, do you hear me?
Yes, I can.
Oh, okay. Thank you very much, Simon, for your presentation. It was really interesting. It's something that it's quite fresh to hear. Also, it's not every day we hear about these sort of issues. And the thing I wanted to ask is regarding the concept of consumer welfare. I mean, I understand that concept in terms of the price of the final product, to say, for example. But how can you value the environmental benefit of that in the authorities' decisions, in the competition authorities' decision? How can they value those sort of environmental impacts, and how can they sort of help the consumer understand the value of that impact? Do I make myself at least somewhat clear?
Yes, indeed. Again, I've discussed this more widely in my paper, but I think focus on two things. One, there are techniques for valuing environmental impacts. I'm not an expert on it, but environmental economics has made tremendous progress perhaps in two respects. First of all, technical progress has meant that we can measure and quantify things. For example, the use of drones and satellites for measuring environmental impacts. And then the economists have developed techniques for valuing that and quantifying that. And those can be taken into account. So just as we should take into account, I see no less reason for taking into account that sort of economics than the sort of economics which are looking at likely effects on price down the line, etc. It's certainly no less certain than some of the techniques that are used at the moment. And the second point which I'd make, which I think is equally important, is that we should not assume that just because we cannot reduce something to a number, that it should not be taken into account. As citizens, as consumers, as competition enforcers, and certainly as judges, we exercise judgment. and we don't reduce everything to financial considerations. As Oscar Wilde said, a definition of a cynic is a man who knows the price of anything, the price of everything, and the value of nothing.
Thank you, Simon. We have another question from Sebastián Ferreira Romea. Sebastián, the floor is yours.
Hello, Simon. Can you hear me?
Yes, I can. Hi.
Hello. Okay. Again, thanks for your time. The presentation was very enlightening and it's very relevant to our daily practice. So my question is, I fully agree that, in a sense, this issue of the competition law analysis into the environmental topic should be driven or in a way pushed by regulation. So in that respect, I wanted to hear your opinion on how effective Margaret Vestager in the Commission is considering the environmental importance into competition law topics.
Yeah, well, I'm a great fan of Commissioner Vestager. It doesn't mean to say I agree with everything, but we had a big conference on sustainability and competition law with the subtitle Bringing the Two Worlds Together, and that's really what I'm trying to do. And she gave a speech there, which I've cited many times in my paper, and she says many, many things that are really helpful. I think her staff are still very nervous about being about the issue because they feel that because it's something new, they're almost frightened of something which they feel is it's something new. But for example, Commissioner Vestager said she emphasized the importance of companies cooperating together. She recognized that that was often the most efficient way to achieve sustainability goals. She said that the competition establishment was too conservative in the approach it took. So there are many, many things which she said, which I think are extremely helpful and which we can frankly, as I have done in my papers, cite back at her. And finally, she invited us to bring our cases to her. And a number of us here in Europe, for example, in the Inclusive Competition Forum, we're trying to find some appropriate cases to take to her and other competition authorities to say, look, no, this is, can you confirm that you don't have a problem with this? Some competition authorities are more open to that as well. I particularly single out the Dutch competition authorities. I think they've done some great work on their prioritization principles, which they plan to update. And Martin Snoep, the president there, is certainly progressive, and I think his views and my views are very, very similar. And indeed, he's made constructive comments on my paper. Another person who's contributed to my paper was the chief economist at the UK Competition Authority, and he said to me privately, which I mean, he gave me permission to say, repeat this, it's in my paper, Simon, I agree with nearly everything you say.
Okay. Paulo here again. Regarding the conference you mentioned in Europe, it's online. If anyone wants to watch the video, it's I think like 8 hours video, and there are lots of panels on sustainability and competition law. And
October 24th, the Brussels conference, yes.
Yeah, I remember, that was my birthday. There's another question from Agustin Ciboldi. He asked, I mean, one approach from competition law might be to consider both positive and negative externalities from the energy resources, which are neglected under the pure price analysis, Agustin says. Would you agree with that view?
Yes, I think it's certainly a potential way forward. It's something which I only really came across. I mean, obviously I knew about externalities. I mean, well, perhaps two comments. One, I find the term externalities a little odd the more I think about it, because what we're saying is that if I produce something which has certain costs, I take into account some of those costs, those in my factory. But if I produce a lot of pollution and the local state, the state has to pick up the costs of those are considered to be externalities, sometimes something outside the cost of production. All we're really saying is a matter of policy. Those do not have to be taken into account in the accounts of the company because somebody else is paying them. They are still costs, and they're still real costs. And second comment I'd make is there's been a lot of development on true cost pricing and true cost accounting. And I think that's something which could be considerably developed, particularly for those who like to quantify everything, particularly our economist friends. There's some excellent work being done in the Netherlands on true cost pricing, if anyone's interested.
Okay, thank you. And I think that also is perfect for our next presentation. Our next speakers will definitely touch on some of the issues you just mentioned in your answer. I don't know if is there anybody else who wants to make any question. Please send the message via chat here on the Zoom. Or if not, I think let me try to unmute everybody and give a...